On a public road.
Don't, please. I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it Domino's Pizza? I mean...
When power goes unchecked, arrogance takes over, but not under Judge Fleischer's watch. Today, we're looking at the moments he put arrogant cops back to their place.
I mean, the only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and over.
Starting off, a police officer finds a man asleep in his car with the engine running, leading to DWI charges. But in Judge Fleischer's courtroom, that evidence doesn't hold up for long.
Sir, you are charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 17th, 2025, an officer was dispatched to a call for service at the 400th block of West Gray Street, Houston, Harris County, Texas. Upon arrival, the officer observed the defendant sitting inside his vehicle. The officer made contact with the defendant and observed the defendant to have bloodshot eyes, unsteady balance, and was confused. The defendant stated he didn't have anything to drink. A Houston Fire Department employee, the wheel witness, stated the defendant was asleep in the driver's side of the vehicle with his foot on the brake and the vehicle in drive. The wheel witness stated he had a hard time waking up the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HGN, 5 out of 8 clues observed on the walk-in turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were .179 and .175.
Where was he?
It sounds like, yeah, I don't. So it says that he was sitting inside his vehicle on the 400th block of West Gray Street, which is accessible to the public. On a public road.
Don't, please.
Even with a 0.179 breath test, the case lacks a key piece of information, whether the car was actually being driven. Judge Fleischer demands clarity, and slowly the gaps in the report become clear.
I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it Domino's Pizza? I mean...
It says it's on a public street. It says, well, more specifically, it says 400 block of West Gray Street. It's a public street.
I mean, I need more information. I mean, does it say he's on a street there, or are you assuming?
No, I'm not assuming. I'm saying what it says is that the 400th block of West Gray Street is a public street. It doesn't say specifically.
Doesn't ask him if he's driving, none of that in there? I mean, really?
Yeah, he did have the vehicle in drive with his foot on the brake and was unconscious. But in regards to the location aspect of it, there's something further stated on that.
I'm sorry. I'm going to find no probable cause. I can't just go forward with assumptions here, you know? Be safe, man. You know, we have every single day. Look, this weekend, how many people died on the road here in Harris County? You know, really, be smart.
Thank you.
You know, you have but one life. Don't do something where you either ruin your life or, more importantly, ruin someone else's life. Okay?
I appreciate
Please
that.
take a seat for me, sir. I'm going to find no probable cause.
With no confirmation if the car was ever on the road and no evidence of driving, Judge Fleischer ends the case for lack of probable cause. And if you thought the last takedown was satisfying, this next one will have you cheering from your seat.
Is that the basis for the reckless driving, the unsafe lane change? Is that what you saw?
I did not observe any vehicles having to take evasive action.
Up next, Judge Fleischer takes on what appears to be a straightforward reckless driving case against Deshawn, but as the hearing unfolds, things don't add up.
You are Mr. Deshawn. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Your Honor, I apologize. Maybe sure.
Deshawn is D-E-S.
Your Honor, on March 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle make an improper turn, nearly causing an accident with the vehicle turning next to him by turning into the wrong lane. The defendant then traveled 88 miles per hour in a 50-mile-an-hour zone and made an unsafe lane change while speeding.
That's it?
Yes, Your Honor. The information the charging instrument alleges that the reckless driving is based on a willful and wanton disregard for the safety of persons by driving more than 35 miles over the posted speed limit.
What began as a simple reckless driving case quickly shifts as unexpected gaps appear in the evidence.
Reckless driving, Judge, do you want him up?
No. I had a bit of an issue with this. That's why I wanted to appoint him someone to see. Go to the left, out of view. There we go. Can you read me the DIMS again, Alex? Please?
Yes, Your Honor. So on March 27, 2025 in Harris County, Texas, officer observed the vehicle made an improper turn, nearly causing an accident with the vehicle turning next to him by turning into the wrong lane. Defendant then traveled at 88 miles per hour in a 50 mile per hour zone and made an unsafe lane change while speeding. Also, I watched the video for this one, so I can answer questions on what actually was observed or what I observed on video.
So let's break it down.
Complaint, it basically alleges unsafe lane change. It doesn't really.
Is that the basis for the reckless driving, the unsafe lane change?
Word for word is recklessly drive a vehicle in willful and wanton disregard for safety of persons and property by driving more than 35 miles per hour over the posted speed limit, making unsafe lane changes, causing other drivers to have to take evasive action and avoid collision with the defendant's vehicle.
Is that what you saw?
As I did not observe any vehicles having to take evasive action. What I observed specifically was the defendant coming out of the parking lot on Theater Road. He does cut across 3 lanes to go to the far lane. But I didn't see any vehicles having to take evasive action, slam the brakes on. In terms of speeding, I'm not sure if he was speeding or not, but it did look consistent with the flow of traffic with the exception of passing other vehicles.
The police report described a dangerous driver racing at 88 in a 50 zone, endangering everyone around him. But when the courtroom sees the real footage, the truth takes a very different shape.
Coronado?
That's,
I'm going to admonish you.
I think that's fair, Your Honor.
Come up. Who is it again?
Brandon.
Mr. Deshawn, do you watch the news?
Yes, sir.
Do you really? Do you really watch the news? Every single day in our county, someone dies because of a boneheaded move that's made in a car. Every single day. Not just one, multiple lives are taken on our streets just because people drive in such a manner that they end up killing someone. Yours is not the worst, and I'm going to find no probable cause. But be safe. You know, we're not asking for much. Don't drive unless you have a license. Don't drive unless you have car insurance. I tell you, I get so many emails every week because people, how can you help me? Because I have someone that's suing me for $50,000 because I got into an accident and crashed and I broke their car. They literally ask me to represent them and help them because they don't know where to go to, where to turn because someone filed a lawsuit against them. Get car insurance. And when you drive, do it in a manner that you're not going to injure or kill someone. We're not asking for much. All right?
We had a conversation about that already, Judge.
Be safe. It's not much. You know, if you got to get somewhere in a hurry, leave earlier. All right? All right. I'm going to find no probable cause in your case. All right? Take care, man. Be safe. If I see you back, it's not going to go.
With one ruling, Judge Fleischer declares there's no probable cause, dismissing all the changes against the defendant. If you thought that was intense, wait until you see how Judge Fleischer calls out these officers for their shocking behavior.
He's leaving. He's leaving. Right? It's like, here, let me come and mess with you more. That would only... Right? So it's like adding fuel to a fire.
Moving on, we have a routine trespass hearing in Judge Fleischer's courtroom that spirals into chaos after the defense reveals a stunning oversight that could tear the case apart.
So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not.
On January 10, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back. and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. So, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and...
You didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know about that?
and
Yes,
aggressive
Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance, somebody's asking him to leave, they're yelling and screaming at each other. Police coming up and saying, hey, I'm the police, you can walk away from that all day long. My client did walk away from that.
According to the report, officers arrived to handle a disturbance and approached the man, identifying themselves as police. But when he walked away, instead of complying, things quickly escalated.
My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement, I smell marijuana, you look intoxicated, because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. If he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, we identified ourselves as police, so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
The defense attorney pushes back, arguing that the defendant had every legal right to walk away and the officers had no lawful basis to detain him in the first place. Every action that followed was tainted from the start.
The reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw
So
signs.
the trespass investigation ceases because he's leaving.
Right.
Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to...
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more,
That would only,
right? So it's like adding fuel to a fire.
they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave. It would undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know if it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them.
Judge Fleischer doesn't hold back. After carefully reviewing the evidence, he ruled there was no probable cause for the arrest, a decision that completely tears the prosecution's case apart. The next clip shows just how far some cops will go until Judge Fleischer steps in with a dose of reality.
The officer goes to interview the complaining witness, I'm
Yes.
assuming, and doesn't see anything?
I don't see any indication that they saw anything.
Next up, a man appears before Judge Fleischer on charges of assaulting a family member, but the case starts to crumble the moment the probable cause report is read aloud.
So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Law enforcement officers were dispatched to a disturbance at 70 Carlton Woods Creekside. Law enforcement officers observed a white male sitting on the curb of Kukendall Road, arguing with his girlfriend on a cell phone. Law enforcement officers had received an additional call of a disturbance of two individuals coming from a neighborhood party. They observed the complainant and defendant to be highly intoxicated. An Uber had picked them both up, and they both started fighting in the Uber. The Uber drivers pulled over.
Fighting in the Uber?
In the Uber, yes, Your Honor. The Uber driver pulled over. The Uber driver stated to officers that the defendant was slapping and punching the complainant, who was the defendant's girlfriend. And the Uber driver had called the security officer on duty to get help with the situation. I'm sorry, Your Honor, it's reading directly.
DVD's here. I don't know if Sebastian's had a chance to even look at it yet.
Sebastian, stay close to that area. Don't come here.
The prosecutor lays out the allegations, but the moment Judge Fleischer starts asking questions, the entire case begins to fall apart.
The defendant started walking towards the officer, dropped the pill bottles, and kept saying, "Leave me alone, get away from me." Officer asked the defendant what it was that they're trying to hide. Defendant said that that's marijuana. The defendant was combative, telling the officer to fuck off. Officer made contact with the complainant witness, said they were a party, they both got drunk and started fighting when they got in the Uber, and the complainant witness stated that she did not feel pain. And I think that's where we're at.
Do they see any visible injuries, anything of this nature?
No, Judge, as far as that goes, what's in the DIMS here is that the witness stated that he observed the defendant with enough force that she covered her face, fell to the floor, and that the witness observed the complainant based on her actions to appear to be in pain. Specifically that the punch was of such a force that it caused her to fall to the floor of the vehicle and cover her face after she was punched.
Again, Judge, to answer your question, there's no indication that there were any injuries at all, any marks, and as he just read, she said she did not feel pain, she did not want to press charges, and I have an affidavit on prosecution as well that I'm going to be getting to the state.
Of course, we don't need necessarily direct evidence. Pain can be something that can be inferred based on conduct. We understand that, a punch of a certain amount of force from a witness's perspective.
Did they get any statements from the person who saw the punch
Again, that was the Uber driver. And that's what the Uber driver said, that based on what they saw, the punch had enough force that it caused her to fall to the ground, covering her face.
The officer goes to interview the complaining witness, I'm
Yes.
assuming, and doesn't see anything?
I don't see any indication that they saw anything.
And she says, I felt okay. And I do not want to press charges.
The alleged victim told officers she never felt any pain and had no visible injuries. While the Uber driver claimed the man had punched her, the officers failed to properly follow up on that crucial detail.
Mr. Child, there are people in life when they drink, they're the life of the party, they're fun to be around. And then there are those when they consume alcohol, they turn into aggressive, mean son of they have no business drinking. If this is you, don't drink. You have but one life. You start racking up cases, you start racking up convictions. All you're doing is you're hurting yourself. Be nice and good things happen. You're aggressive to cops. You're aggressive here. The only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and over. Don't drink if you're going to be in jail. You know, really, we have enough death and dismemberment in our city now as it is. Don't be on the news. All right, I'm going to find no probable cause.
Thank you, Judge.
Judge Fleischer calls the report utterly terrible, ruling it far too weak to move the case forward. Still, he delivers a firm warning to the defendant about his drinking and behavior, making it clear that poor choices can have serious consequences. Well, that brings us to the end of this video. Today, we saw how arrogance and misuse of power can backfire when faced with true justice. Judge Fleischer made it clear that no badge or uniform places anyone above the law. These moments serve as a powerful reminder that respect, honesty, and accountability matter, especially for those meant to uphold the law. If you agree, make sure to like this video and subscribe to see more cases where justice puts arrogance in its place.